Hello, everyone. We are at the World Arbitration Update, and this is the session on practical steps in CSR, corporate social responsibility, and human rights assessment. First of all, we would like to thank our sponsors. They are right there in front of your eyes and screens. It would be almost impossible to make the World Arbitration Update sustainable unless we received some sponsorship. So we're very grateful to all of them. We're also very grateful to our supporting organizations. We have over 50 supporting organizations of World Arbitration Update. Our mission is twofold. One is to update on issues of public international law and also international, commercial, and investor state arbitration, with an emphasis to the broad international community. And when I say the broad arbitration and international community, we really mean it, because each of our panels has no fee for any attendee. So we are really reaching the 5 continents, Asia, Oceania, the Americas, Europe, and Africa. And our days, as you know, are divided in 5 days of the week. The first one for the Americas, the second one for Africa, the third one for Asia, the fourth one for Europe, and the fifth one for just topics that are combined and they're for everyone. So today's is the Americas, and this is our second panel. And with us, we have a really true and an exceptional panel of experts. I will not do the introductions. I will simply introduce our moderator, who has been a force behind all the panels that we have done in World Arbitration Update, as well as in the Washington Arbitration Week, which is the sister forum of WOW. This is Doug Cassel, Professor Cassel, and also his counsel at King & Spalding. Professor Cassel is a widely recognized expert on business and human rights, international human rights, as well as public international law. He has taught in the fields for many years, for decades actually, most recently at Notre Dame Law School, where he was a presidential fellow. And he has also taught and lectured on subjects of human rights and business at leading universities, including in Belgium, England, Hungary, Mexico, and Spain. And he has published more than 100 scholarly articles and reviews. Also, on the field of practice of law, he has represented international law experts. He has also represented retired diplomats, and also he has participated and acted in drafting of amici curiae in 8 cases before the United States Supreme Court, and advised in 2 others. I could keep on going, but I really don't want to embarrass Doug. He has been a force behind this panel. He knows best who have written and moved the needle forward in terms of business and human rights, and I'm grateful that he's here. With that, I will turn to Doug, not before apologizing to everyone, because I never said who I was, which I will do now. My name is Jose Antonio Rivas, and I'm a co-chair of World Arbitration Update. And together with Ian Laird, who's the other chair of the World Arbitration Update, we have created this forum, which has now its 2nd edition. So hopefully you'll be engaged and completely enjoy it. And thank you. Doug, the floor is yours.
Thank you very much, Jose Antonio, for that embarrassing introduction. We now have the privilege of listening to an all-star lineup of people who really are experts in the field of business and human rights. I apologize for not giving the introductions that each of them deserve, because if I were to do so, we'd have no time for the substance of the panel. So I will just say briefly in alphabetical order that Stefan Burbach is with Trinity International. He is listed by Chambers as a senior statesman among global leaders in business and human rights. And for the rest of his introduction and that of our other panel members, I refer you to the web pages of their respective law firms that are listed in the program. Elise Gruel Digs is with, among other places, Bedford Row Chambers. Now Chambers, the rating agency, lists her as an eminent practitioner among global leaders in business and human rights. And among her many other activities, she was the founder of the Advisory Committee on Business and Human Rights of the American Bar Association. Nathan Langford, who we will refer to in this panel as Nate, is founder and practice lead at Miller and Chevalier of the Business and Human Rights Practice. And Ray Lindsey, because LI comes alphabetically after the other names, is also listed by Chambers in Band 1 of Business and Human Rights. She is the co-head of Public International Law and the BHR, the Business and Human Rights, which I will call BHR practices at Clifford Chance. I will give an extremely brief topical intervention on the subject that business and human rights is in a period of what I'll call epochal change. 30 years ago, human rights was widely considered a matter for governments, not for businesses. 10 years ago, human rights had become recognized as relevant to business, but as only a responsibility of business, mostly a soft law responsibility. Today, human rights is increasingly recognized as a hard law obligation of business. There are national laws requiring human rights due diligence in various European states. The EU Corporate Sustainability Due Diligence Directive is expected to be approved in 2023. Recently, since we're on the Day of the Americas, there is case law of the Inter-American Human Rights in the Mosquito Divers versus Honduras case. There's also a treaty in the Western Hemisphere, the Escazú Agreement, both of which impose human rights due diligence obligations. On top of the expansion or the hardening of business and human rights norms, human rights, the concept is also expanding. Only in July of this year, the UN General Assembly recognized a new universal human right, namely the human right to a clean, healthy, and sustainable environment, which of course is very relevant to the topic of business and human rights. These trends, I suggest, are likely to continue in time and to expand geographically. And we'll hear more about that in the panel, which will go for the next 90 minutes or so. We will focus on the legal developments in business and human rights and how they affect advice to business clients. We will only briefly link to international arbitration at the end. We focus on business and human rights because we expect that while many of you are familiar with international arbitration, you may be less so with respect to business and human rights law. Our format is that each panelist will speak briefly, followed by comments from another panelist. Elise will begin with an overview of business and human rights norms, which she depicts as a galaxy of norms. Stefan will then shift from Elise's broad overview to a specific country experience, namely that of France under the Loi de Vigilance enacted in 2017, which in effect requires large French companies to engage in human rights due diligence. Nate and Ray, in that order, will then each address issues in the business and human rights advice they give to clients and the kinds of questions clients raise. As part of his response, Stefan will then comment on broader trends in the field. I will then spend only a few minutes on how this all relates to international arbitration, and we will then have closing remarks by each panelist, and if time permits, questions and answers. And so with that, Elise, the floor is yours for 9 minutes.
Thanks a lot. 9 minutes. Okay, thanks a lot, Doug. Okay, so I want to talk to you about a framework, a human rights framework and business and human rights. So over the last decade in my practice as an international human rights lawyer focusing on business and human rights, I have noticed a remarkable expansion of corporate liability together with soft law responsibility that has taken a variety of forms. The current legislative situation reveals a global patchwork. There's a wide variation in purpose, framing, enforcement, interpretation of legislation. Let me give you a few examples. We have in France, as Doug says, Stefan will go extensively about that law, but I cannot not mention it because it's the first one of its kind. Adopted in 2017, it offers a general framework covering issues of human rights, environment, health and safety in the workplace, fundamental freedom and civil rights. It's incorporated into the Commercial Code of France, but the law can be litigated in front of civil tribunals, not just before commercial instances as first envisaged. In the UK in 2015, it adopted the Modern Slavery Act. That law touches upon both criminal and labor laws, and it also touches upon corporate reporting. It was recently amended in 2019 to reinforce its framework and obligations. We have the US-California Transparency Act of 2015 that amended the US Tariff Act of 1930 with the power given to Customs and Border Patrol to act as at the border with power of impounding shipments, negotiating with suppliers. This US law represents a different reporting system compared to that of the UK. Both the US and the EU have new regulations on conflict mineral and conflict timber, also including corporate reporting and affecting trade law. Australia in 2018 adopted a Modern Slavery Act like the UK that mandates companies that have an annual income of more than $100 million to publish an annual statement on their risk associated with modern slavery throughout their operations and supply chains, and on the measure they intend to adopt to face the risk, to mitigate and prevent them. In 2021, the Germans adopted a law on corporate due diligence in their supply chain. The new law mandates corporations to fulfill their duty of due diligence in their supply chains relative to internationally recognized human rights and also a number of environmental norms. In 2022, the Norwegian Transparency Act that requires companies to promote respect for human rights was adopted. It also promotes decent working conditions, including a provision on living wage. On 24th of February 2022, the European presented its draft directive on due diligence. Ironically, and I say that without humor, the same day the war in Ukraine started. So it's easy to remember the date. It proposes to put in place a series of due diligence measures relative to risk of serious harms to human rights and environment, including combating climate change. Recently, some amendments were proposed to that directive. They're pretty extensive. The result that we have is a patchwork of legislation, not a coherent legal approach. Different laws in different jurisdictions, different focus, different frameworks, different enforcement mechanism. And then there is also built onto this a patchwork of soft law. The most coherent of soft laws are the UNGPs and the OECD guidelines of 2011. All this leads to a confusion, and the lack of systematic enforcement only reinforces the confusion. As a human rights, using the language of the UNGP, this is what I call a governance gap. I mean, quoting John Ruggie, who was talking about that government enforcement. Norms were adopted to palliate this gap of gaps and eventually shape hard law. Soft law helps advise clients and begin reforming institutions. Soft law is
Elise, we're having some trouble hearing you.
global
Your
in
connection is
scope,
not
and is
strong.
built from consensus and can go fast, can be adopted fast. In this new world, orders sovereign are no longer the only rule makers, and that's worthy of mention. So I'm at maximum, and that. Can you hear me now? What to say and what to do, because I'm connected.
Yes, we can hear you now,
Let me go
Elise.
into chat. You can. And where did you lose me?
It was just the last minute or so.
Okay, so I'm gonna just repeat a few points. I was talking about the patchwork of legislation that was not coherent, and the legal approach of this patchwork makes that we have different jurisdiction, different focus, different framework, enforcement mechanism that vary from jurisdiction to jurisdiction. There's also, that's also built onto a patchwork of soft law. The most coherent one is the UNGPs and the OECD guidelines of 2011. All this leads to confusion, and the lack of systematic enforcement only reinforces the confusion. As a human rights lawyer, using the language of the UNGP, this is what I called, as John Ruggie defined it, the governance gap made of mixture of no clear body of laws and weak enforcement. Norms were adopted to palliate this gap, as soft law can be adopted quickly to fill the normative gaps and eventually shape the law. Soft law helps advise clients and begin reforming institutions. Soft law is flexible, global in scope, and built from consensus. In this new world order, sovereign are no longer the only rule makers. To answer the rising challenges of economic globalization, we suggest that the world will benefit from a matching process of legal globalization that will encourage the development of an international body of law that reinforces progressively a regime of corporate liability. The French duty of vigilance and all the other laws being adopted in Europe, as well as the case law expanding the duty of care in several jurisdictions like Canada, the UK, and Netherlands, amongst others lately, can all contribute greatly to this process and need to evolve in the same direction, mirroring trends in international law. The galaxy of norms, to make sense of this space, Professor Reagan and I proposed a tool that helps better understand the space described above. We called it Business and Human Rights as a Galaxy of Norms. It's a global map of soft and hard law and norms viewed together. It proposes legal tool to help lawyers navigate and interpret this new universe. This expanding galaxy is made of hard law, such as binding national legislation in several countries, for example, to combat corruption and forced labor, soft law and international norms as the UN guiding principles that underline the second pillar to create a responsibility for corporations to respect human rights. It also includes the OECD guiding principles on multinational enterprise combined with private voluntary initiatives, as well as jurisprudence or case law on the duty of care as a corporate standard setting of conduct, responsible business conduct, often with extraterritorial reach. All these solar systems of norms should push corporations to adopt due diligence frameworks to ensure responsible business conduct and respect for human rights as required by the second pillar of the UNGP. Our framework suggests that these new laws and proposed frameworks on human rights and environmental due diligence should be seen as part of the Business and Human Rights Galaxy of Norm. That galaxy offers guidance on how these laws should be construed and applied. These new bodies of law show a tendency to harden the legal liabilities of multinational corporations throughout their global supply chain. At the same time and in parallel, there is an expansion of legal obligations for corporations to report publicly on policies they adopt to prevent and manage those risks. These non-financial reporting obligations are becoming the norm in national legislation and also in international soft law. This creates powerful incentives for corporations to adopt and implement the corporate social responsibility programs that are showcased in their sustainability and CSR reports. In our Galaxy framework, we suggest that the duty of care is evolving continuously and in parallel in many jurisdictions, so that corporations need to develop compatible policies and measures that apply consistently to all the territories and countries where they operate. The Galaxy is designed to identify both the hard law and the soft law together and look at emerging norms. Try to map how they interact. Are they conflicting, converging, or whether they are big gaps? Sort the norms looking at different types of duties imposed by hard law and the norms and looking at the enforcement mechanism. And we list 5 rings of liabilities. The ring 1, which is responsibility for outcome.
Elise, thank you very much. I don't think we have time for the 5 rings.
That's okay. That's
a
okay.
great
That's okay.
Intro,
That's
and now we'll proceed to Nate, who has 3 minutes to
question
give
me.
observations on Elise.
Thank you,
Thanks
Doug.
a lot. Were
Thank
you
you,
able to
Doug.
hear me in the end?
Yes, we were.
Yes, thank you. Thank you.
Good,
No, that was
good.
great.
Sorry about that. I have no idea what happened.
No, no worries, no worries. So thanks, Doug, and thanks, Jose Antonio, for inviting me and bringing together this great group. I want to say, I guess, just in response to Elise, I love how you think of this as a galaxy. I mean, I think it really captures that this is dynamic, it's complex, it's bright, and as a science fiction geek myself, I get it on that level too. So I think it's a great concept. I think it's very important. Obviously, I think we all agree that that lawyers advising multinational companies these days, it's really important for us to understand this spectrum. And I think particularly for people involved in arbitration and arbitrators, being able to identify what are genuine human rights issues and what standards should businesses be reasonably held to these days can be very helpful for your practice. The importance of these hard laws in the galaxy, I think, is really self-evident, and I think it fits with the traditional role of lawyers and enterprise risk management frameworks in terms of managing legal risks, traditional legal risks. I feel like most of my discussions on these topics in the galaxy really focus on what do we make of the soft law part? How should we really think about that? And I think that a couple of themes that Elise mentioned that I just want to reinforce and agree with is that I really think of it in terms of emphasizing a few key things that with the importance of this soft law framework is that they are applied to your company and are shaping the hard laws. And I think that you heard from Elise about that sovereign nations are no longer the only sole rule makers these days, that you sort of see where hard law is going by looking at these. And then I think it's also important, the soft law part of it, in terms of frameworks that are applied to your company by stakeholders that affect your access to markets, to financing, and to customers. I think a great example of this, and is one that Elise mentioned, is how U.S. enforcement agencies right now prohibiting the import of goods made with forced labor. In their official guidance on how they enforce this, they refer to ILO standards, they refer to OECD standards that incorporate UNGP concepts. So you really see these things making their way into that official guidance as well. ESG ratings, you see these picked up there. And then finally, I really emphasize, like, this is about the right thing to do. Companies have made commitments to the UNGPs to respect the human rights of stakeholders, and these standards provide practical tools to actually do that and prevent adverse impacts to stakeholders. So I think, just to try to respect your time, Doug, the bottom line is, really emphasizing that it helps to manage potential legal liability, binding commitments with your business partners and expectations of other stakeholders, and then your company's own commitments is the way I think this really is very important for us all to understand.
Thanks very much, Nate, and we'll hear more from you when you're up as a
Thanks a
presenter.
lot.
Now we go to Stefan, who has 6 minutes to speak to us in English about France.
Thanks a lot for saying that. Indeed, it's always a little bit different when it is in a foreign language, but I try my best. In fact, to say that the Rana Plaza, in which some French companies were mentioned, by the way, was in 2013. So just after the UN Guiding Principles and several commitments from companies with voluntary CSR policies. These proved to some extent that binding regulation on respect of human rights, including the supply chain, was a key. In conformity with the duty to protect provided by UNGPs, France adopted the French Vigilance Law on human rights and environment. Soft human rights law into hard law, extraterritoriality, and challenging the corporate VL. This was seen as a legal revolution, thus necessary change of mindset for business and lawyers. That also concerns tribunals and courts, including in international investment arbitration. Kofi Annan and John Ruggie were the origin of this changing world, humanity and dignity in business. In France, as some other countries, vigilance is at the heart of the galaxy very well described by Elise, galaxy of norms, a galaxy not easy to handle for business and lawyers. Hard law is the heart of legality, but cannot stand alone, neither for business because they need financing and compliance, nor for courts, because they will interpret in the light of UNGPs, Paris Agreement, free prior and informed consent, and other soft law regulation. And this is exactly the case of what is happening in France. French vigilance law is a 2017 and was a compromise. Companies were rather against the binding law, and there are still some of them against the hard directive. And this for competition reasons, the very famous level playing field. As a result, there was a short law in France of 4 articles, but some terms were so unclear, especially in Article 3, that the Constitutional Court decided to delete it. So there were 3 remaining articles, but still, it's not because some terms were so unclear that you could not provide for some criminal offense that there is not still a need to interpret those terms, and that will have to be done by business and lawyers and courts. But so far, no decisions except procedural. The law focuses on prevention, the duty of diligence, and also role of NGOs and courts, who have a role to play, as indeed may be asked by anyone to require a company to comply with its obligations before it goes to litigation. Concerning civil liability, the law says clearly that any continuing failure to comply with its obligations, as listed, but indeed subject to interpretation, that's what we call a named fault, by the law, would make the company civilly liable, it is tort, and obliged to compensate for the defined severe damage that the compliance with these obligations would have been made possible to avoid. The law itself obviously describes some limits and content of the liability. What are those obligations? In simple words, there are about 265 companies incorporated in France, which must each year design, implement effectively to be interpreted, and publish, it means make public, a plan called Vigilance Plan. Due diligence is said in some other instances, but in France it is called Vigilance Plan, in which it shall anticipate possible reasonable vigilance measures which will make the company to be able to identify all risk, it means potential negative impacts on people, and to prevent severe violations of human rights. I insist, to identify all the risk and to prevent severe violations of human rights. And this resulting from its activities, but also from the activities from those companies it directly or indirectly controls, decision-making power, its suppliers and subcontractors, and it is said with whom it maintains established commercial relationship. But at the difference of what has been said in different instances, it was made clear that it is not because it is said established commercial relationship that there is a ranking. It shall not be stopped at rank 1. It can go to rank 2 and further. The plan should be designed with stakeholders. It could be an advantage to avoid liability or to mitigate. and include, and there is no choice, because that's the basis for obligations from companies, a mapping to identify, analyze, and then prioritize all risk. As a result, today, 20% are inexistent. Some are vague of those plans, and there is a lack of prioritization. Even some companies, and that's the case today with McDonald's France, in injunction, as I mentioned earlier, with the role of state before litigation, has been asked to produce a plan because there was none. Secondly, companies subject to do the plan must do regular assessment of mapping of risk concerning the affiliates, subcontractors, and suppliers. It makes sense. Thirdly, which is the most important one, they must take appropriate actions to mitigate the risk or to prevent, of course, serious impacts violations. This can be linked to the idea in the Young principles of causing, contributing, and linkage. And in fact, the modification of the directive we just read, and it is transmitted me a very useful document, does identify now back in the directive the linkage, contributing, linkage, and causing. They had some first decisions, but there is no real decisions. It's only procedural. It's a fact before litigation, the court has been held by some NGOs to ask to some companies to comply with their obligations pursuant to the law. For example, for Total Uganda, they've been asked to review the shortcoming in its plan. Also, it has been asked to implement expropriation indemnities. In fact, there were claimed duty on breaches of vigilance for its affiliates in Uganda and Tanzania. One can say that, in fact, it is interesting to see that the Parliament in Europe, the 15th of September 2002, has denounced the violation of human rights by that company in Uganda and Tanzania. Teleperformance, the risk of violation of some workers' rights. So it has been asked that it should be included in the plan. EDF, but the case is closed now, wind farm project. There was no free, prior, and informed consent. You see a reference to some soft law, to some extent, soft or hard, it depends. And then thus no vigilance to communities. But that's a long story because NCP, the 12th of July, decided to close the deal. And before that, the 2nd of June, 2022, still, in fact, the sale of energy by EDF was refused by the company in Mexico, so the file is closed.
Stefan, I apologize, but can you bring it to a close, please? You're a bit over time.
Total for Climate ordered to change to adapt its plan to the 1.5 degrees. Suez, civil liability for consultation with communities. Casino asked to adapt its policy, not correctly implemented, and that's about it. So that's a closing. And today, so much to happen in months to come. Several EU directives to become Vigilance, corporate sustainability, ESG, forced labor, Green Deal, and taxonomy. That will be in the 3 months to come. Quite some work for all of us.
Thank you very much, Stefan. And now, Elise, you have 3 minutes to comment on Stefan's presentation. You're muted, Elise. You need to unmute. Elise.
Hear me now.
Now we can, yes.
Good. Thanks a lot, Stefan, for this excellent presentation. So I have a lot of good things to say about this law because this law was the driving engine of huge changes in Europe. I remember back in 2014, 2015, when all the big companies in France were so opposed to that law. They were basically enraged at the thought that they could be controlled by such a law. And finally, when the law was adopted in 2017, some of them rallied very fast, others not so fast, but they are rallying to the law and they are trying to do what they can to abide by the law. Where the weakness of implementation has been happening, in my opinion, as a human rights lawyer, is the stakeholder engagement. There has been very weak stakeholder engagement, and I believe if they were reinforcing that aspect of the law, which is very clear in the law, but it's even clearer in the European directive, I think they would gather information and they would be much better equipped to deal with the most salient risks that they meet in their operations. As Stefan say, the obligation is to prevent, it's to address all risk, but to really prevent all the salient risk. There is no room for error. They have to prevent these risks. They have to do a mapping of their supply chain. They have to identify where the risks are to the different objects of the law, which is, as I said, I mean, environment, human rights, safety at work, and civil liberties, but they have to make sure that their actions prevent the occurrence of severe harm and risk. So there's no room to let these risks happen. And that's what the plan is supposed to make happen. So if there is no plan, I could almost say there is a presumption that they're not doing their job. I mean, it's not stated that way, but suffice that an association goes before a court saying, we have suffered such damage and there's no plan. Then the court will turn around and say, where is your plan? You have to provide a plan so these associations can sue you. So, I mean, this is how European law is built. This is very much part of the argument of the galaxy, that once you have one of these laws that was built in part on the British model of the UK Modern Slavery Act of 2015, but very different because it belongs to a different system. These different systems operate a gravitational force on each other, and the galaxy starts to expand. You see other norms appearing, other laws appearing, case law developing, and then you have a space that's becoming busier and busier and busier, and the liability is becoming more expensive. In the case of the French law,
thank you very much, Elise. I'm afraid your time has expired, and we'll now go to
Thanks.
Nate for 6 minutes on issues
Thanks a
arising
lot.
from his advice to clients, and of course you'll have some words later, Elise. Nate, the floor is yours. You're muted.
Thank you, Doug. So I think what I hope is of interest to people is some flavor of what it looks like for companies that take this area seriously. Like, what do they do in practical terms? And in my experience, most practical BHR advice is based on a combination of two things. First is applying the UN guiding principle framework because of how universally accepted it is and how integrated it is into so many hard law expectations. And secondly, incorporating traditional best practices of corporate compliance programs, which I think many of us are familiar with in other contexts, but applying them to the BHR set of risks. So as we talked about earlier, the UNGP framework is focused fundamentally on respecting the human rights of stakeholders. And what does this respect concept really mean in practice? Well, first, it means having a clear policy commitment from senior management that the company is committed to respecting the human rights of its stakeholders, meaning that it commits to not interfere with stakeholders' enjoyment of their rights. And of course, the primary responsibility of countries, governments to protect human rights, it stays with them, but it's up to companies not to interfere. That should be in a policy statement. Second, this responsibility to respect requires due diligence to assess your risks and to mitigate them, which clearly is incorporated into the French laws that we were talking about and many of these other norms in the galaxy. And then third, to facilitate effective remedy when a company has caused actual adverse impacts. And so this framework means that companies in practical terms start with a general policy commitment, and it's either a standalone commitment or a policy statement or a policy on its own, or incorporated into a code of conduct. And due diligence, that concept is really where I see companies spending the most time, most effort, most resources on due diligence. And so what does due diligence mean? I think for some people coming from other fields, you hear the words due diligence, you may think of, oh, this is something we do to vet a particular supplier that we're thinking about hiring, or an agent to make sure that they're not going to engage in misconduct or something like this. In the BHR world, the concept of due diligence is much, much broader. So it really encompasses many different aspects of what are traditionally thought of as components of a broader compliance program. So it includes assessment of risks, acting on the findings of your risks so that you mitigate them, and then monitoring to make sure that those efforts are effective and that your efforts continuously improve over time. And then finally, communicating with stakeholders so that there's more accountability and transparency about what you're doing in this area, which again, you can see all of these concepts reinforced in taking shape in hard laws like the French law. And so when you think of how broad this due diligence concept is, you can start to see how there are many opportunities to leverage companies' existing corporate compliance programs to address these types of risks. And so I'll just give one example here, just in a practical level to hopefully bring this to life. But for risk assessments, let's say you have a particular operation that you are concerned about the human rights risks to stakeholders there. What kind of existing processes in your compliance program can you leverage to help assess that? Now, many companies would already be, say, sending attorneys, auditors, whatever, there to assess other types of risks, like in an anti-corruption risk assessment. And so one trend I've seen is companies using those as an opportunity to more broadly assess risks, including human rights risks. And what's interesting about that is that you can't just apply traditional concepts to the BHR world. You have to keep in mind what really makes it special about the UNGP framework is that it requires much broader engagement with rights holders, those whose lives may be adversely impacted by the company's operations. So much more engagement with workers, community members, to understand where the risks and possible impacts are. And then another obvious area is third-party controls, and I think this may end your just relationships with business partners. And so you can obviously having processes in place to conduct risk due diligence on those business partners, and also to build in the right safeguards into contracts, which I'm sure is relevant to many people from an arbitration perspective. Leveraging those existing processes in terms of your business relationships to capture that. But again, going farther, because you're looking not just at your direct impacts, but sometimes farther up your supply chain. So risk mapping your supply chain is very much prioritized in a challenging area that I see a lot of companies spending a lot of time and effort with. And I guess just to wrap up this sort of like intro, I mean, I could obviously talk all day about this, and I think all of us could on this panel. But I think, and when I think about this in practical terms, I think about opportunities to leverage existing compliance program processes to address this risk area in an effective, efficient, feasible way, but to not lose sight of the fact that you need a rights holder perspective involved, which will shape these things differently, and that you will need more transparency, communication to facilitate accountability and the right kind of stakeholder engagement. But I hope this is helpful, but I'd love to hear what Ray or others have to say on this topic too.
Thank you very much, Nate. And that's exactly what we hope to proceed to now. Ray, you seem to be coming back into the screen, and the floor is yours for 6 minutes of issues that arise in your advice to clients.
Thanks, Doug, and thanks, Nate, Elise, and Stefan for those great overviews of what this all means. as Nate has touched on, human rights due diligence under the UN Guiding Principles is very different from other forms of due diligence, in the sense that the focus of it is impacts by business on rights of people. And that's very much at the core of any due diligence exercise that's aligned with UNGP or the OECD guidelines or some of the new legal requirements that are coming into effect. So risks to the business itself, which would generally be the focus of business and of their lawyers, is a secondary part of it. It's a legitimate part of what you're doing, but the focus of human rights due diligence is really to identify and then address and account for impacts on people and to remediate when appropriate. So in addition to the idea of a process that may be built into enterprise risk management, HRDD under the UN Guiding Principles does incorporate concepts of the actions that are expected once potential and actual impacts have been identified by the company, those impacts on people. And in order to understand what those are and how to address them, that requires human rights expertise to understand the standards that are applying and what those impacts might be and what the company's relationship with them could be, assessing what the company's involvement with them is, whether it's causing, contributing, or linked to the impact, because that is relevant to an identification of what action is expected under the guiding principles to address those impacts. And so it's what's happened with, I think, the French Vigilance Law, and others will correct me, and the draft Corporate Sustainability Due Diligence Directive is an aim by states to build due diligence obligations that are grounded in and reflect the expectations of the UN Guiding Principles and the OECD guidelines for multinational enterprises. But that is really challenging because the responsibility to respect human rights is not a legal obligation on companies. It reflects a societal norm, and what the legislatures are having to do is translate concepts that are not legal in nature in the guiding principles into legal obligations on companies. And that can be proved to be quite clunky, because as the UN Working Group has reported to the General Assembly in its discussion on human rights due diligence, it's not a science, it is an art. And I think this is one of the real challenges for businesses, is the really difficult human rights challenges, the impacts that create real dilemmas for business if they are involved with them. Those are the really tricky ones that businesses have to work through. And that requires a real appreciation of what it is you can do with the information that you gather in your due diligence, the feedback that you're getting from stakeholders, and then working way through those in order to prevent, mitigate, or if necessary, remediate those impacts. And it's that process I think is proving troublesome, certainly in the EU context. The current corporate sustainability due diligence proposal seeks to incorporate the elements of the guiding principles in the OECD guidelines, but has been criticized for being quite prescriptive as to the steps that should be taken to address impacts. It doesn't, in its original form, really adequately account for this nature of the involvement of the company to assess whether it's a causal connection or a contribution or a linkage. And it has a tendency to encourage sort of tick box compliance-based approaches using contracts, etc., in a cascading fashion. Now, contracts and other forms of leverage are very legitimate mechanisms for companies to use to try and manage human rights impacts and risks. But as I said, this is more an art than a science, because template clauses in supply chains will rarely make a practical difference to the people's rights at the end of a supply chain. What's really important is for businesses to understand the nature of the impacts with which they're involved and to really think through how they can address those in a meaningful way. And that can be very challenging when the actual impact may be quite far down your supply or value chain. So in relation to this, it's really important for internal stakeholders within companies for a cross-functional approach to these issues. So you require the human rights expertise. You need to be talking to your lawyers. The business people on the ground need to understand what they're doing. The sustainability function will have a role, the human rights function, your security people if you're in a high-risk area. And all those constituencies need to be brought into the picture to and sort of get the idea of human rights due diligence under the organization's skin. So it's as much about capacity within organizations to really understand what human rights impacts look like and what the expectations are on the business to deal with them, and making sure that that is implemented throughout those systems, whether it's in plans to address adverse impacts, preventive plans, corrective action plans, and through contracts. But all of that, as I say, it requires very subtle application of those instruments depending on the information that's come out of a human rights due diligence exercise. Also, it's very much an ongoing method of identifying and addressing adverse impacts. Ultimately, as Stefan said, the idea is to prevent adverse human rights impacts. And so if done properly, it can be a way of, for example, companies avoiding themselves being on the end of claims of having caused impacts or harm, and therefore potentially of having these issues sucked into arbitration. Now, I'm not an arbitration expert, and I know Doug is going to correct anything that I get wrong, and certainly expand on and improve what I have to say. But my understanding is that there are now efforts to incorporate elements of to place obligations of a social and environmental nature on investors in the context of international investment agreements, so that in future those might give rise to arbitrations and claims that would involve companies' failures to adhere to those standards. This might include an obligation to undertake human rights due diligence, etc. And so you may see in the future that these might form the basis of claims. It seems to me that also in an arbitration context, now that we have these national laws that impose human rights due diligence obligations, that depending on the applicable law in a particular arbitration, that a tribunal might well have reason to look at whether a company has in fact adhered to the home state's requirements on its due diligence. Because under, for example, the CSDD, any company making an investment would be required to undertake human rights due diligence in relation to that. And obviously timing on that is key. Secondly, as I understand it, human rights arguments may also be raised against investors in the context of where they've raised human rights issues in arbitrations, or in the context of counterclaims, where the argument might be that that a company has impacted on human rights and therefore should not be entitled to recourse under the investment arbitration agreement, even though the state may have been deficient in meeting its own obligations. And an example of that is there's a Peruvian case, Bear Creek, I think, where Philippe Sands had a dissenting opinion where he took account of the fact that there had been unrest in relation to a mining concession, and whether the company had contributed to the fact that the concession was then brought to an end and there was an alleged expropriation, that the company's compensation was reduced, the award was reduced by half to reflect that the fact that the company had not properly established its social license to operate. I think what comes out of that is, having looked at that part of the dissenting opinion, is that one of the challenges, I think, in arbitrations is an understanding of the state duty and obligations in human rights and the corporate responsibility to respect, and then these overlays of domestic legal requirements and how they're all going to intersect to affect particular claims, etc. And then last but not least, I think we can expect to see commercial arbitrations where the kinds of contracts that Nate talked about contain human rights related provisions, including to implement the outcome of due diligence, and whether companies have been in breach of those. And of course, last but not least, the missing part continues to be the fact that all of these measures are supposed to be effective in protecting rights, and the fact that, a lot of these, the implementation of HRDD, either on a voluntary basis or through legislation, is not demonstrably yet improving the lot of those who are affected by business activities. And secondly, that most arbitrations obviously do not really give opportunity to those who are affected to bring claims where their rights have been infringed. I've probably gone on way too long, and Douglas, it's now over to you to put me right on arbitration.
Thank you very much, Ray. And now we turn back to Stefan, who has 3 minutes. If you wish to comment on what Ray said, you could do that, or if you wish to look more broadly than the French experience you described earlier, the floor is yours, Stefan.
Yeah, thank you very much. I think so much has been said by Nate and Ray. It would be impossible in 3 minutes to comment on all those excellent things. 1 or 2 points. First, the UNGPs is still applicable, and this is what I said to any French companies. Whatever the size of the company, whatever the sector of activities, whatever the number of employees, whatever the turnover, UNGPs will still apply first. And this is what I said to my clients. I say, careful, you better apply UNGPs if it goes further than French law, for example. So it means that if you comply with UNGPs, then you will comply with French law, but at least you might go further, which is the case, by the way. That might be the same with a directive to come. There are many modifications in the draft directive to be published, released soon. But this is something important. The second thing is many issues concerning the burden of proof. The burden of proof is a key issue, and it has been pointed out in the draft directive of the new one of 13th of September 2022, where there are now some real thoughts on how to deal with that so that victims would have less to do, in terms that companies have some obligation to communicate and publish their plans, and therefore they publish and they make it known publicly what they ought to do, and they have no choice than to do that. So this might have some role to play in a burden of proof. I won't expand too much on that. Then the social license, arbitration, and other issues. Get back to what Ray says concerning the causing, contributing, and linkage. In fact, this is very interesting to see that the new directive, the new draft, as I said earlier, will raise those issues. So instead of establish commercial relationship in the supply chain, it is now accepted that the reference shall be causing, contributing, and linkage, with the consequences attached to those notions. And this is very interesting. I like what you say, Ray, to understand on how to do. Indeed, it is not an easy thing for business, because all we speak about is a real big change in the mindset for business and for lawyers. And there's still a lot to do with this. Awareness for business and lawyers should continue to be done very, very seriously. Concerning the social license, indeed, that social license is a strange notion to some extent, but it makes us lawyers and business, but for us lawyers to have think twice. It's not anymore to advise clients on a legal license to some extent, but also on the social license. And the social license is not only hard law, as it would be the case for us in France and in Europe, but as I understand, the way that we think and we consider those issues can sometimes be different between where the countries have hard law and where the countries like in the US, where it is less hard law, or some other countries. But again, I want to say that we speak of universal values. And for this, I would claim that UNGPs, whatever hard law, shall still be there and shall be used. In fact, the soft law, UNGPs and other soft law, shall be used by courts and tribunals, and it is the case already in France. And this is new, to use some sort of public international law for business and for decisions in business. This is very strange and very new. Sorry, not strange. This is very new. Now, concerning arbitration, I think, Doug, there will be so much to say, but I'm afraid my time has elapsed. So I will close there. Indeed, there is the sword and the shield in international investment arbitration. And why? Because the state is always in some sort of defense. And as we know, because protection of investors, protection of human rights, that's to some extent have to be equal. That's what has been decided in some decisions. But in reality, BITs, and Doug, that's for you to expand, BITs still have a lot to do in order to really take into account that well balance between those two issues. Merci beaucoup.
Thank you very much, Stefan. I'm now going to expand a bit on the relevance of what you've just heard to international investment arbitration, going a bit beyond what the helpful introduction that Ray gave. As any of you who are involved in investment arbitration today know, the bilateral investment treaties and other treaties that create possibilities of investor-state dispute settlement through international arbitration, the treaties that are in force now almost never make express reference to the phrase or the words human rights. And not surprisingly, very few ISDS arbitral tribunals to date have expressed, have pronounced on issues of business and human rights. And frankly, in the rare occasions when they've done so, in my opinion, they've mostly got it wrong. It is as if international investment law and business and human rights law are somehow in two separate worlds, even though they're part of the same public international law. But this is changing in recent years. Business and human rights is now increasingly mentioned in the operative provisions of new bilateral and multilateral investment treaties. In the next 3 to 10 years, these changes in the treaties, combined with the hardening of business and human rights law, about which you heard, are likely to become subjects of litigation in ISDS arbitrations. For examples of the changes that I'm about to note, you could consult, for example, among many others, the 2021 Colombia-Spain bilateral investment treaty, the 2019 Dutch model BIT, and the 2016 Morocco-Nigeria BIT. Not all of the changes I'm going to mention are in all of these treaties, and they take different forms in the different treaties. But all of the changes are apparent in at least some of these recent treaties. Now, neither the two BITs, Colombia, Spain, or Morocco, Nigeria, are yet in force, and the Dutch model BIT has yet to be applied to a single new specific BIT. But they all indicate trend lines that are remarkably different from BITs of the past and are likely to continue, expand, and enter into force in the next decade. So in summary, what are the changes? And they come in at least 4 areas. First, there are now explicit references to human rights. Sometimes those come in the preamble, but of course, as public international lawyers know, the preamble is important for interpretation of the entire treaty. Secondly, they are now also in many cases in the actual text of the operative provisions of BITs. Second, there is clarification of the human rights responsibilities of states to reaffirm their right to regulate for human rights and the environment. And as I mentioned earlier, environment is now part of human rights as well. There is a reaffirmation in these new treaties of the state duty to protect human rights and of the state duty to ensure access to effective remedy. When you put all of those together, arbitrators will now have license, indeed, I would suggest a mandate to consider issues of human rights when they are evaluating state actions that affect investors. Thirdly, with respect to investors, there are explicit references to the human rights responsibilities and in some cases of obligations of investors under the UNGPs, the OECD guidelines, and other provisions. And also there is reference to civil liability in these BITs, civil liabilities of investors in their home states for injuries and loss of life they cause in the host state. Finally, in the particular area of ISDS, there are now specific provisions that at least one, if not more, tribunal members should be qualified in the field of international human rights law. And the express provision that ISDS recovery may be denied altogether, or instead have the damages reduced, as happened in Bear Creek, as Ray mentioned, because of violations by a company of its BHR responsibilities and obligations. So with all of those provisions coming into treaties, it's important that arbitration lawyers be ready for them, because they will be applied in the coming years. Now we have time for concluding remarks by each of our 4 panelists. I think we could go in reverse order at this point. Ray, would you like to begin with 2 or 3 minutes of closing comments?
Thank you, Doug. Just picking up on some of the more recent remarks. I mean, Stefan is an indomitable optimist in terms of the future of the guiding principles. I think there's a real risk to the guiding principles approach to human rights due diligence and its objectives if the laws that are coming into effect are not crafted very carefully, and if they are taken as a ceiling by companies rather than, and it's questionable how many are going to be willing to go beyond and continue to adhere to their spirit in terms of implementation of the guiding principles. So I hope Stefan is right. And then just picking up on something you said, Doug, is how extensive is the responsibility to respect human rights? And I think there's lots of definitional and language issues that also come out of the attempts to translate the UNGP into legislation, for example, in what is an adverse human rights impact, what are companies' responsibilities, when do they translate into violations, etc. And then the proposition that the environment is now part of international human rights, I think, is controversial. I think the new right to a healthy environment is not an internationally recognized human right. My view, but I don't think international law has progressed that far. There are differences, obviously, in some countries, depending on their constitutional positions, but that's one that's going to be fought out for a long time to come. I think one of the challenges going forward is obviously for international lawyers, business and human rights lawyers, arbitration lawyers to recognize the parameters of what they're talking about. There's going to be a lot of scope for dispute on some of these issues going forward. But I think the conflation of international, there's lots of criticism of, does international investment law ignore international human rights law? I think that the attempts to transpose international environmental law concepts into international human rights law is one that needs to be treated very carefully. You'll be familiar with, the recent report of the Philippines Human Rights Commission, which makes various leaps of logic, in my view, in that regard. So I would just say that that's an area that is for discussion and exploration going forward in the future. Thanks.
Thank you very much, Ray. Nate?
Thank you. That's fantastic. And I think, aside from these obviously hugely important policy discussions, I think that one thing, if for people who are maybe new to this area, I think I might just end with a plug for really reinforcing, I think, what's a common theme through all of the discussions today, which is this is a really important time to really become conversant in these concepts and what it looks like for a company to be living up to its responsibility to respect human rights these days, because it's essential for us as lawyers to be able to serve our clients that in our traditional roles, where they rely on us for issue spotting, in terms of being able to see a genuine issue and to raise it, a creativity in terms of how to apply these standards and the spirit of these standards to the actual realities of business, and also just independence, where we as professionals come at things and are really uniquely positioned to understand rights holder approaches and to give voice to them effectively to top management, so that the right actions can be taken. And so this trend, I see it only continuing, and so it's, again, it's just, I think it's just a crucial time to really just become conversant and have familiarity with this area.
Thank you, Nate. And before we hear from Stefan and Elise, a housekeeping item that I neglected to mention earlier. When we conclude with the panelists, standard practice in Washington Arbitration Week, and I believe in this update as well, is that we are broken into small groups where one of us will be in each group, or maybe two, and some of you as well, for informal chat on any subject. So with that reminder, that will begin once Stefan and Elise have made their concluding comments. Stefan?
Yeah, thanks a lot. In fact, Ray, without playing on words, I have a dream. And my dream is that we speak of universal values. Human rights is universal. The UNGPs have been adopted, and I will remember all my life the way it went on when we were with Ruggie and all the team. And you were there, Ray. And it has not been easy. Same when we got adopted in 2015 and 16 at the IBA level, the Practical Guide for Business Lawyers and other instruments, all based on UNGPs. And I have a dream, is that universal values in human rights can be implemented in a universal manner all across the world. Whatever our culture, whatever our religion, whatever our system of law, whatever our languages, I dream that we will one day have those common bases and common tools, as the UN Guiding Principles is a common tool in order to implement. Indeed, Ray, I agree with you, it's a dream. But I've always thought that to dream is not necessarily bad. And to have a good dream when it is a nice dream, it is something that we can share. So indeed, I will remain optimistic and a dreamer. And I will work for my dream to become reality, because I'm not the only one. It's not my only dream. So how to do for us as lawyers is to be convinced that we should act as wise advisors, as it has been insisted, and John Sherman was speaking a lot on that, to demystify human rights and make it for lawyers that indeed we speak of social license and legal license at the same time. And that when we advise clients, we take the risk sometimes to say, come on, listen to me. You do a big M&A transaction, but I would like to speak on human rights at the same time. I can say that very often other partners in corporate departments or clients would say, no, we have no time for that. We should all say, we're going to take some time for that, at least a few minutes, because this will make the world to change. It takes time to bring awareness. It takes time to change the mindset of people. That will take time. It takes time to make people not thinking about short-term money, but to have long-term plans for the planet and for our kids and grandkids and others. That will take time. That's a dream as well. I'm a real dreamer.
Thank you, Stefan. I think we'll need to end there and pass the baton to Elise, and congratulations on your dream. Elise? And you'll need to unmute, Elise.
Yeah. So like Stefan, I'm an absolute dreamer. I'm an idealist. I mean, if you work in human rights, you have to be an incredible optimist, because it's very hard at time to. They just stopped my video. I don't know why, but anyway, maybe because they can't hear me when I'm.
That's right. It's an improvement on your audio.
That's good. So that's fine. So what I want to leave people, the thought I want to leave people with, I mean, to prolong on what Stefan is saying, is that as a human race, we are at a crossroad right now where, I mean, all the problems are converging. I mean, we have an incredible economic situation. We have once in a humankind lifetime planet crisis, climate crisis. We have a big war where we don't know where it's going to end, with a leader that's threatening nuclear war. And we have an economic crisis that's looming, and we have rampant inequality. So in spite of all the instruments we have built, inequality has just grown. So we have to talk to business and investors to tell them that they can really make a difference here. That if they decide to go on the side of human rights and on the side of environmental protection, they will fend off these fascist leaders that are springing up everywhere. And these fascist leaders, may I remind you all, are not concerned about economic development. They don't care. They don't care if they pillage their country, ruin their country. They're very dogmatic people. All they want is raw power and dominance. You can see what's happening in Russia. You can see what's happening in Iran. You can see what Trump wanted to do in the US, what Orban has done to Hungary, what Bolsonaro has done to Brazil. So business has a choice. They have a choice to side with human rights and environment for the future of the planet, or they will just bow out and just become the puppets of fascists, because fascism is rising, and fascism is due to the fact that there's been such inequality. People are lost, people are in quest for direction. And I believe together with lawyers, business can play a real leadership role in taking the path to development, to progress, to sustainability. I believe more and more investors understand that. They don't want to invest in oil and gas anymore, or less and less, because they know this is gone, this is going to be gone. And it's true for many other fields. So this is where my dream takes me, Stefan, is that we have to appeal to leadership so that they take the decisions to support human rights, to support the planet, to support sustainability. If not, we are heading to a catastrophe, which I really don't want it to happen.
Thank you very much, Elise. Right now, we'll be heading to the breakout sessions, and I assume the administrators will do whatever is needed to make those happen. But thank you to all of the panelists for what I have found to be an engaging and informative set of discussions. Thank you all.
Thank you, Doug.
Thank you, Doug.
Thank you.
Thank you.
Thank you very much, Doug, and thank you, Elise and Stefan, Nate, and Ray. This has been an incredibly rich and useful panel. I believe that for any person that would be interested in human rights and business, as well as its interaction with investment arbitration. Not only because you masterfully were able to identify the basis of business and human rights, but to go beyond that, how that has been in many ways implemented in many jurisdictions, in particular in France, and how that is now being sort of heightened in the investment arbitration world through bilateral investment treaties that have specific references to human rights and social corporate responsibilities. There's one much more treaty that I wanted to reference, which is the free trade agreement between Canada and Colombia. That one has a specific reference to social corporate responsibility standards, if anyone wants to check it. And now we would like to give way to the breakout rooms. Each one will be sent to a different breakout room, hopefully. So please take it away, and let's move into the breakout rooms. And thank you very much.
Thank you.
Thank you.
Thank you.